interest communities and homeowners associations to order for Friday, January 10th, 2025. Just as a reminder to members, we do have time allotted until 1 o'clock, as this is our last in the series. I believe it is meeting 10, if I'm not mistaken. But the agenda may be off there, but on affordability and civil rights is our topic for today. And we are going to start with moving the minutes. Do I have someone willing to move the minutes from January 6th, 2025?
So moved, Madam Chair.
Thank you, Member Green. That said, let's go ahead and go to a vote. All those willing to approve the minutes, please say aye.
Aye.
Unmute, please.
Aye.
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 Any opposed? All right. Hearing no opposition, we will go ahead and approve the minutes for January 6th of 2025. And with that, I'm going to recognize Ms. Pollock to share today's agenda.
Thanks, Madam Chair. Right now, we're in the welcome and purpose section of the agenda, followed by 15 minutes for public testimony. Then we'll hear a number of presentations. Firstly, a presentation by Cameron Rifkin from the National Conference of State Legislatures with the national perspective on the issue of affordability and civil rights. And then we'll have presentations 2 and 3 from subject matter experts, including Shana Jimenez from the Housing Justice Center and Nick Erickson from Housing First Minnesota. The majority of the meeting will be used for discussion and recommendations. We'll also take a short break in between agenda items 4 and 5 because we're extending today's meeting until 3 hours instead of the usual 2 hours to allow for additional work time. And then we'll adjourn. And just an announcement that the upcoming work group working sessions will be next Friday, January 17th and Friday, January 24th from 10 a.m. to 12 p.m. via Zoom. Thanks.
All right. Thank you, Ms. Pollock. For the general public who may not be in a part of the work group, we will have just a couple of quick things here and some reminders. The purpose of the work group is to study the prevalence and impact of common interest communities and homeowner associations in Minnesota, how existing laws regulating CICs and HOAs help homeowners and tenants access safe and affordable housing, and that can be found under Minnesota Law, Chapter 127, Article 15, Section 48. In terms of decorum for today's presentations, just a quick reminder, we know this is a passionate topic, so we do ask that everyone please remain polite and have a high level of decorum at all times. Please direct all comments through the chair. That means if you have a question, please ask your question and the chair will the chair will call on you to ask a question or to ask you for your response. Time limits, we do have time limits, particularly around some of the presenting and so forth. The chair does reserve the right to move things along wherever necessary to keep us on topic and make sure we respect everyone's time. Our meeting agendas are structured, of course, to provide information for the things the work group is tasked with studying, with the expectation that each member will add their valuable contributions to the discussion and questions and answers as well. Please note, presentations and materials by speakers and testifiers are their own. They are not the opinions of the work group. And thank you finally to the work group members and the public who've attended all of the listening sessions, including the one in Burnsville yesterday. We got some really good nuggets out of that one. And I also want to take a point of privilege to thank all of the members for being a part of the work group and having stuck with us all of these meetings. It has been really a pleasure to work with all of you and to hear a variety of interesting perspectives. We did mention also the longer time today, and we will have a small break in between to allow folks to have a bio break or grab a glass of water or whatever is necessary to take care of ourselves. And with that, we're going to move on to public testimony. We do only have one public testifier scheduled for today, so I will go ahead and move to that. I do want to remind the testifier that we do have a strict time limit of 3 minutes. Mr. George will work the timer, and you'll hear a bit of a chime when your time is up. And we would ask that at that time you conclude your comments so that we can move on to the next. That said, we have Mr. Steve Horvath of Homeowners of America United. If you would like to go ahead and state your name and affiliation for the record. And if you are local here, your city, and then go ahead and proceed with your testimony. Mr. Horvath.
Hi, thanks very much, Chair Bonner. Steve Horvath with HOA United, Homeowners of America United. I actually grew up, I was born and raised in Rochester, Minnesota. My folks still live there, and I come back and visit often. I live right now in Seattle, Washington. And thanks to the committee for hearing my testimony this morning. You know, I have actually gone back through, I missed out, glad I had this opportunity today, missed out on getting in contact with you earlier. And I noticed that you've had a number of different presentations. It doesn't look like any of them have actually been from the academics who have spent their lives invested in researching this area, at least not that I could see. You've definitely taken some testimony from attorneys and folks representing CAI and the business trade organization. You've also heard from a lot of homeowners, but there's another niche that I don't think you've heard from, who are folks like me who have spent years of their lives dedicated to board service and being homeowners, and also translated that into a nonprofit, something bigger, and also working across the country to try to empower homeowners for advocacy and collaboration. So that's what HOA United does, where we just operate based on volunteer contributions. And what I wanted to bring your attention to in the 2 minutes I have left is really thinking about all of the academic literature that's out there. So there's Private Communities and Urban Governments, Theoretical and Comparative Perspective. It's a 200-page book that was released in 2016. And there's Professor Evan McKenzie, you probably know or have heard of Privatopia and Beyond Privatopia. Those are a couple of books he wrote, probably best known for those. And he does such a great job of highlighting all of the challenges that have existed. And the challenges that have existed for CICs, CIDs, there's different names for them, have truly been around for 30 or 40 years, and people have been writing about them. And so I would just implore you, as you think about writing your recommendations, to take some time to look at that writing, look at those recommendations, what the gaps are, look at how he actually says, despite the mounting evidence that private governments are overly reliant on owner resources and lacking institutional support, policymakers have favored self-protective steps to insulate public institutions from the risk of loss, rather than bolstering the private governments that pose the risk. And so I think that's what you've been tasked to do, is to try to figure out how to get there. The other thing I wanted to mention is that states like Illinois and others have the Ombudsperson's Act. There's these legislatures that have come up with great language to talk about what's going on. You also have not heard from the Uniform Law Commission, who has promulgated a much newer version of the Uniform Common Interest Ownership Act that could, I think, help you greatly. Washington State, actually, I was instrumental, and HOA United was instrumental in helping move forward and adopt the latest version of CICHOA here in our state. And I've put some recommendations. I hope you received the material I prepared for you. And I have a bunch of links and recommendations in that slide deck that you can take a look at. And I hope that will become part of your recommendations. Thanks for hearing me this morning.
Great. Do you have, I know, I'm not sure how we're doing on time here, but are there any specific recommendations you'd like to highlight, Mr. Horvath?
Sure. Thank you, Chair. I put a small handful in the deck, and I'll just very briefly run through those. One thing I would encourage you to really consider is a universal statutory remedy, something along the lines of, if an association violates the chapter, that the remedy is for actual damages and a civil penalty in an amount of $1,000, and the court shall award reasonable attorney's fees to the prevailing owner. And I would also implore you to consider the CICHOA suggestion that's been in that framework for years, that the court has the discretion to award punitive damages if they find that there has been willful disregard for the chapter. That would greatly deter bad behavior. It's something the industry is not very fond of. D&O coverage does not cover punitive damages, but it is a significant deterrent. And it's literally a paragraph of about 50 words that can provide those kinds of deterrents to actually follow the law and the governing documents. I would also implore you to consider retaliation, anti-retaliation provisions like Nevada and Hawaii have adopted, so that if somebody is trying to get their association to simply follow the law and the governing documents, and there's retaliatory behavior, that they have a statutory remedy for what happens. Certainly there are things with a fiscal note and there are things without a fiscal note. So the things on the fiscal note side would certainly be an agency, somebody to go to resolve these things. All of those cost money, and a lot of states like my own and others across the country are facing huge deficits. On the other side, there are simply limiting regulatory overreach. Provide for people to have gardens. Colorado has done that. Require ballots or require directed proxies in elections. Don't just let it be, well, we're going to go around and do proxy harvesting. There are so many levers, dozens and dozens of levers that you could add to the law, and especially the rulemaking provisions of the newer versions of CICHOA. Even the open meeting provision that you have now has been improved, and it now is owners have the mandatory ability to provide feedback, and you can even improve on that, like Washington State is doing this year, and saying, not only do they have that, and Arizona has already done, but owners get to speak before the board makes decisions, right? Not at the end of the meeting where, oh, well, we just had the meeting, thanks for coming. But, and I think you recognize that this public testimony is exactly what you're used to when you hear in the legislature that folks have something to say. You don't make all your decisions and vote on bills first. You hear. So there's just so many little things that you can do that don't cost anything, that you can add to the statute. And I don't have time, and you don't have time to hear all of them, but there's a lot of information that you can pick up from the work that's been done in other states. And California, Washington, Colorado, Arizona, Florida has recently obviously been through a lot and has brought in a lot of sea change in what they require. Putting documents up on a website. If the documents have to be disclosed, if you're of a certain size, 25 units and more for condos and 100 for HOAs, you have to actually post the documents to an electronic place so that your owners can self-serve them, so that it doesn't have to be well, I'd like to get them and we'll just wait, or whatever a reasonable time is. Washington State, we actually have now a 10-day requirement to turn around records, unless that's too short, and then it's 21. But if it needs to be longer, the association has to actually go and get a court order to require it to provide a longer time frame. Adding precision and eliminating the words reasonable and other words that are basically subject to attorney or court interpretation wherever you can, those are all things you can do. So thank you again for hearing from me.
Appreciate that. Thank you, Mr. Horvath. All right. Because we do have Mr. Horvath, but I do want to mention, is there any other public testifiers? Well, we did not have anyone signed up. I'll just take a brief moment, pause. Anyone? All right, then we will move on to the next section of our agenda. And hopefully, Mr. Horvath, you've given your contact information to the staff so we can follow up with you if we have any additional questions on the reference materials you provided. But I appreciate the summary, since many of the general public watching today may not have access to that at their fingertips. So it was helpful to get a brief overview of some of those recommendations. Thank you for that. With that, we're going to move on to the next portion of our agenda for today. We do have Mr. Cameron Rifkin from the National Council of State Legislators, again with our sort of national perspective, to sort of clue us in on some of the things happening across the country. Mr. Cameron is a policy specialist for children and family programs at the National Conference of State Legislatures. He also has particular knowledge of today's topic. So, Mr. Rifkin, when you are ready, please state your name for the record and your affiliations. And I will note to members that we will have a question and answer period after both speakers have had an opportunity to present. Mr. Rifkin.
Yes, thank you, Chair Bonner. I appreciate that. Good morning, everyone. My name is Cameron Rifkin. I am a policy specialist with NCSL's Children and Families program. I predominantly cover topics related to housing, homelessness, and economic mobility. It's a pleasure to be with you here today, and thank you for the opportunity to present on housing affordability relating to homeowners associations and common interest communities. Let's just jump right in. Thank you. So previously, housing was not a big focus of state policymakers. It was mainly a federal and local issue, but it has become a major interest as of late, particularly in the last 3 to 5 years. Some supply side considerations. There's a nationwide shortage of at least 1.5 million housing units, and no state has a sufficient supply of affordable rental housing. This lack of adequate housing affects both renters and homeowners. There's some construction challenges, rising material costs, workforce shortages, lengthy permitting processes, restrictive land use regulations. It's important to note that previously, as more housing was built, even more expensive housing, more affordable properties became available for middle and lower income households. However, this is not the case in our current housing market, and vacancy rates are at historic lows. Some demand side considerations. Current interest rates hover around 7%, which is more than twice the 3% rate averaged across 2020 and 2021. The total monthly payment of a median priced home exceeds $3,000, which is only affordable for 8% of Black households, 13% of Hispanic households, 16% of white households, and 29% of Asian American households. There were over 21 million cost burden renter households in 2023, representing nearly 50% of all renter households. And for reference, cost burden refers to households spending 30% or more of their household income on housing costs. Next slide, please. To address housing shortages and improve housing security, state legislators are exploring a variety of different strategies. Here are some of the notable 2024 housing policy trends. Incentivizing more housing construction, preserving existing affordable housing, revising zoning and land use regulations, permitting more density and expanding transit-oriented development, as well as regulating investor purchases and short-term rentals, and bolstering housing and economic supports after climate disasters. All of these policy levers are intended to increase housing supply, availability, and affordability, as well as prevent displacement and promote economic security. These policies may intersect with homeowners associations and common interest communities, but some may be more broadly aimed at increasing housing opportunities. Different states and communities have different needs, and these varying policy strategies illustrate how it is not a one-size-fits-all solution for comprehensively addressing housing challenges. I'd like to also mention that NCSL maintains a housing and homelessness legislation database. We will begin 2025 legislative tracking soon enough, but you can also learn more about the 2024 housing policy trends using our database. Next slide, please. Housing construction barriers and opportunities. We noted a few of these, but let's dig a little deeper and highlight several more. So barriers include land costs, rising prices for building materials, workforce shortages and labor costs, lengthy permitting processes, which can increase costs and slow construction. On average, it takes nearly 18 months to build an apartment building in the United States. In a survey of developers, 97% reported construction delays, and 83% of those developers said the delays were due to permitting issues. There's also complicated administrative procedures, prohibitory zoning, minimum parking requirements, and building code requirements to adhere to. However, policymakers do have opportunities. such as providing tax abatements and housing tax credits to help stimulate supply, offering financial incentives to developers to offset construction costs, streamlining and simplifying permitting processes, as well as revising zoning regulations and reducing parking requirements. It's an important note that minimum parking requirements can significantly increase costs and reduce the number of housing units constructed. Structured or underground parking can cost anywhere from $25,000 to $65,000 per space in urban areas, significantly deterring development. Next slide, please. A few policies to incentivize housing construction. These are 2024 enacted state legislation examples. So Alabama established the state workforce housing tax credit. California authorizes borrowers to use funds to provide loans for multifamily housing lending programs and construction financing. Hawaii requires counties to issue affordable housing tax credits for programs constructed under the Housing Finance and Development Corporation. Mississippi recently created a pilot program to construct rental units for teachers. Developers would receive loans up to $200,000 at an interest rate equal to 1% below the discount rate at the Federal Reserve Bank, and loans must be paid back in no more than 15 years. And finally, Utah authorizes redevelopment agencies to use funding to pay for or contribute to the construction of income-targeted housing. Next slide, please. So, how does the national housing supply shortage intersect with homeowners associations or common interest communities? Well, many homeowners and home buyers must work with some form of an HOA or common interest community to purchase and maintain a home. Over 75 million Americans reside in a community that's governed by a homeowners association, representing more than 30% of the total U.S. housing stock. And the numbers continue to grow. 60% of new single-family homes are being built in HOA communities. And while there may be a potential increase in home value, with homes in communities with HOAs tending to be worth 5 to 6% more than similar homes without an HOA, these opportunities may not be equally accessible for all communities, particularly people of color. White and Asian Americans disproportionately reside in communities with HOAs compared with non-HOA areas, including other communities with high rates of home ownership. Additional challenges may arise because HOAs and common interest communities tend to have broad authority over housing policies, including enforcing or administering fines, fees, restrictive covenants, and foreclosure procedures. HOAs and common interest communities also may be exempt from state and local zoning ordinances, allowing them more authority in the types of properties they allow and decision-making for accepting prospective lower-income tenants. In response, state and local policymakers are looking for ways to regulate HOA authority and improve tenant or resident rights. This is in hopes of increasing housing access and availability, as well as preventing displacement. Next slide, please. Here are a few of the various ways legislators have limited an HOA or common interest community's authority in order to cultivate more accessible housing. California restricts homeowners associations from establishing limits on rentals and short-term leases of more than 30 days. Colorado prohibits an HOA from imposing daily late fees or fines, while Idaho prohibits homeowners associations from restricting internal accessory dwelling units or ADUs. Texas established procedural requirements HOAs must follow for placing a lien on a property. Homeowners must be given at least 3 warnings prior to a lien being placed. It's important to note that with this law, HOAs are still allowed to force the sale of a home in order to collect money owed on a debt. And finally, Washington restricts the authority of homeowners associations from regulating or limiting occupancy by unrelated persons. As you'll see, each state has taken a different approach based on their needs and priorities. Next slide, please. State policymakers are also exploring ways to remove discriminatory covenants to create more equitable access to housing opportunities. And while these bills may not directly focus on HOAs or common interest communities, the laws apply to residential leases and purchases, and HOAs and common interest communities tend to be the ones responsible for enforcing these covenants. Connecticut prohibits restrictive covenants based on race and allows homeowners who discover a racially restrictive housing covenant to file an affidavit with the municipal clerk and have the covenant voided. Illinois allows homeowners and property associations or housing cooperatives to legally compel the voiding of a discriminatory covenant. And Michigan allows homeowners to file a form with their local register of deeds, notifying them of the need to remove any discriminatory language in a property deed. And finally, Missouri voids any restrictive housing covenants related to race, color, religion, or national origin of any person and considers these deeds unenforceable. Next slide. Thank you. I really appreciate this opportunity. I know we have limited time, but please check out these great NCSL resources that we have to offer, including our Housing and Homelessness Toolkit page, which is essentially a one-stop shop for NCSL's housing and homelessness publications, including the ones listed here. I briefly mentioned our legislation database, as well as a policy snapshot focused on increasing the housing supply by reducing costs and barriers. And of particular interest for you all might be our housing supply webinar series as well. Thank you again. There is one final slide, I believe. Thank you. Thank you. I think we have some time for Q&A, but otherwise, please feel free to reach out in the future. I'd be happy to assist with any questions, concerns. As I mentioned, I predominantly cover housing, homelessness, and economic security, but our Children and Families program covers a wide variety of topics, including child support and family law, child welfare and the prevention of child maltreatment, early childhood, as well as food security. So thank you again, and I truly appreciate the opportunity to be here.
Thank you, Mr. Rifkin. And my apologies, I think I misspoke earlier in talking about the two presenters. I was skipping ahead in the agenda.
No.
In this portion of the agenda, we only have Mr. Rifkin with us today. So my apologies for that. So we are going to go to Q&A for Mr. Rifkin. And I see Member Murray has a question.
Hello. Okay. I'm not on mute here, and audio is working. Excellent. Mr. Ripken, I had just something that came up while you were presenting about minimum costs and extra burdens, is that the minimum parking requirements in mini metro areas are also like a mandatory accessibility component for creating accessible housing stock. How do you recommend that we balance those? And also of note, like I was just working with Mapping Prejudice at the U of M, attending a couple of their, they've done wonderful work on racial covenants here in Minnesota. And during one of their meetings that they were holding, we discovered that most racial covenants also would cover disabled people. Like if you're disruptive or forgetting the specific wording, but it covers the R word and like a bunch of other derogatory phrases for disabled people. But how would you recommend we adjust both to keep housing costs low while creating as many accessible units as we can, and to make sure we're expanding like any language for covenants to the margins as well to catch everything?
Yeah, thank you for that question. I'd like to just put in a note that if you're not familiar with NCSL, we tend to not make recommendations or advice. So we're not here to kind of tell anyone what to do or not to do, but we can highlight some examples that have happened across the country in other states. And so it's an important point that you brought up that there are considerations when you're reducing parking requirements in terms of accessibility. The research shows that parking requirements and minimum parking requirements tend to take up a large footprint of developments. And so if you reduce those, you have more opportunity and more incentive for developers to build housing units. And some of those housing units could be restricted for folks with disabilities. They could be floor level units. that have, accessibility additions to them, handrails, less steps. I can certainly dig in a little deeper. There have been a lot of state legislation examples to reduce parking requirements. I would be curious to know how that has played out with particular demographics of folks, including folks with disabilities. So it's definitely something to consider when adjusting these requirements for developers in terms of their footprint. The second piece is interesting. There is a wide range of restrictive covenants, as you mentioned, race, color, national origin, religion. And so my understanding would be that states can and could pass similar legislation that prohibits any sort of discriminatory language. This might not be exactly what you're looking for, but we've also seen legislation that prohibits source of income discrimination. And so if folks receive a housing voucher, there are states, there are communities that prohibit that prospective tenant from moving in simply because they receive a housing voucher as their source of income for rent. And so there are several initiatives, legislation aimed at removing that type of language as well and prohibiting that sort of discrimination. So my understanding would be that if this work group finds that to be a need and priority for Minnesota, that type of language could be substituted for race, religion, national origin, source of income. You could certainly include language that says, you can't prohibit folks based on disability. I'd like to point out that I'm not an attorney, but there are certainly federal laws and federal regulations that, refer to the, ADA and prohibit that some level of discrimination already. And so, yeah, I think it would be an interesting task for this work group or state policymakers to explore what type of language that includes and how they can expand access for a wide variety of folks, including folks with disabilities. Does that answer your
Madam-
question a little bit?
Thank you,
Madam
Mr.
Chair,
Rifkin. Mr. Murray,
very
is that
quickly,
any follow-up?
I guess, Mr. Ripken, what I was trying to gently and pointedly ask was, they stack. Like, disability on average requires 19% more income to account for it. And you usually aren't just disabled. You may be African American, you may be whatever your walk of life, disability is another layer which we probably all will encounter one day. And that was what I was concerned when I didn't hear the stats for demographics disaggregated by with and without disability. Because my friends who are from different demographics have a much harder time affording an already unaffordable house when they have to add $25,000, and the state of Minnesota won't cover part of that or most of that cost because it's shared with other people and it's not just for their benefit. So that was specifically what I was asking for clarity on. Okay, how do we do this so that we hit the ethnic demographics and we push to the margins there? So thank you.
Thank you.
Thank you,
Rep.
Member
Bonner.
Murray. And I will
Chair
just
Bonner, may I respond just briefly
yes,
to that?
absolutely.
Yeah,
Mr. Rifkin.
Thank you, Representative Murray. Thank you, and I appreciate you bringing this up. I can certainly dig a little deeper into some of these data points, and I know we're on kind of a time constraint here. And personally, I could probably talk about housing for months. So 10 minutes is a little bit of a short time, but I'd be happy to find more data and disaggregated data, particularly targeting folks with disabilities. And as you mentioned, it's co-occurring situations. It's not simply just one thing. I would like to briefly just mention there are legislative initiatives at the state and local level regarding universal basic design principles. And there has been more movement, initiatives, effort to focus on those and what those look like for communities and how some of these HOAs or common interest communities can implement those design standards to not only benefit folks with disabilities, but to make everyone's life a little easier. I know a common example is, lit sidewalks for folks with mobility issues, but also folks with strollers and in shopping and commerce areas and stuff like that. And so I appreciate you bringing that up. I'd be happy to connect again. Please get my information and we can talk more and, give you more detailed reports all about that. So thank you. And thank you, Chair Bonner.
Thank you for that, Mr. Rifkin. I do also want to point out, and please, I know research is often listening in, so if I misstep, please feel free to correct me, Mary. But I do believe Minnesota in the last several years has made some significant strides to the point around racial covenants, of avoiding those covenants, as well as providing mechanisms to get those deeds cleared so that those covenants are no longer a part of that deed. And so I just wanted to make that notation here for folks listening in who might not be aware of that statute. So thank you for that.
Yeah, and Rep Bonner, thank you, Chair Bonner. I appreciate that. I would like to just note that I tried to avoid highlighting some Minnesota examples because I figured, preaching to the choir a little bit here on this group.
Yeah.
I do a few other examples, including one that may be of interest in Washington, where they established a covenant home ownership account and program to address the history of housing discrimination due to racially and ethnically restrictive real estate covenants. The program provides down payment and closing cost assistance for first-time home buyers in the form of a loan. And secondary to the primary mortgage loan, the loan has a 0% interest rate and it is paid back on the sale or refinancing of the home. And there are more details about who is eligible and all of that good stuff. But yeah, if there's more legislative examples, I'd be happy to provide those as well.
Thank you for that, Mr. Rifkin. And I know the Housing Committee has been looking at a number of approaches to deal with first-time home buyers and encourage affordability for homeownership, especially for those folks who maybe have not had a family history of owning a home. So thank you for that. Any other additional questions before we move on to the next portion of our agenda? I am not seeing any other hands. With that, Mr. Rifkin, I want to thank you for your time today. I certainly appreciate you being here. And of course, if any members have questions or follow-ups for this particular testifier, please make sure to reach out to myself or to staff, and we'll make sure to get you in touch. Thank you, Mr. Rifkin, and for your time today.
Thank you, Chair Bonner. I appreciate it.
All
And thank you all
right.
for being here.
Thank you. All right. With that, we're going to clip right along to make sure we have more time at the end for discussion here. We do have, in the next part of our presentation, we do have two subject matter experts with different perspectives coming to the fore here. We have Miss Shana Tomenes. I'm sorry I didn't get a pronunciation on your last name, Shana. So hopefully I'm saying that correctly and you can correct me if you will. But Ms. Tomenes is a housing litigator at the Housing Justice Center. And I will remind people where I previously had jumped ahead that we do have two presenters today and we'll do Q&A for those individuals after both have concluded. All right. Ms. Tomenes, if you want to go ahead and state your name and affiliation for the record and go ahead and proceed with your presentation.
Yes, thank you, Chair Bonner and members of the working group on Common Interest Communities and Homeowners Association. My name is Shana Tomenes. I'm an attorney at the Housing Justice Center. The Housing Justice Center is an organization that has a longstanding interest in the preservation and production of affordable housing generally, and the protection and rights of people to have safe, affordable places to call their home, free from discriminatory barriers. My expertise is not within HOAs specifically. Rather, I've worked with and advised Minnesotans who live in common interest communities, and I work significantly with resident-owned manufactured home communities and within manufactured home communities who propagate rules that affect all the homeowners within a manufactured home communities who rent the land in which they live. I also would say personally, I've lived in a townhome community in Stillwater with an HOA, and my mom owns a townhome with an HOA community that she rents as a landlord out. So I come with that kind of perspective. After this meeting, there's written comments that'll be submitted from Ivory Taylor at the Housing Justice Center, who has extensive knowledge on HOAs generally and this issue specifically, and lived experience with the barriers and issues related to HOAs. I want to talk a little bit about, because I really appreciate that you're talking today about the civil rights and affordability issues here. So HOAs have a long-standing history of discriminatory practices and systemic exclusion that's occurred across the United States, and including Minnesota, and it still impacts both the wealth gap generally and the homeownership gap specifically. Although the Supreme Court ruled racially restrictive covenants were unenforceable in 1948, HOAs have continued to maintain racial, religious ability, familial status, and economic exclusivity through more of a less overt lens. They often use the guise of things such as neighborhood standards or community controls to uphold what ends up being de facto segregation. This phenomenon has been well documented in research and also in the book The Color of Law, which maybe many of you have read, which calls out these issues both in Minnesota and nationwide. The need for regulation and education, I see it as both a racial justice issue, a disability issue, and to protect homeowner interests. I'm a practical person, and I always say we start with a practical issue, which is we want to talk about who is making a lot of these decisions on the HOAs and how they are affecting the whole community in general and Minnesota as a state. In many cases, HOAs are made up of homeowners who live within that community. And in theory, that's great. Often the people who are taking on this burden are doing it as a volunteer basis, and they're doing it because they feel strongly about it. I know that's true in my community, and I know that's true in many communities. However, I'll say that the best systems work, including HOAs, when people feel supported and they understand what the rules of the road are. Currently, there are no requirements for people who are in HOAs and representing their communities to be representative of the community, and they're given significant power over financial and community rules that affect their neighbors and the homeowners in the community. There's no issues or requirements that people have become subject matter experts in disability law, reasonable accommodation, or have education on racial issues or affordable housing issues. And now I'm not saying that that's what the standards should be, but I'm saying we have normal people doing their best. And they come into this space with no ill intent, but they come in without a lot of framework to understand how to best serve their neighbors when making these decisions. The decisions that they make disproportionately negatively impact BIPOC and disabled homeowners living in their communities. So we really need to make sure, in my opinion, to make for reasonable rules that protect homeowner property owners and better the community as a whole. I kind of want to touch on 3 issues and recommendations to solve this. And that's related to, first, providing minimum standards for HOA rulemaking, protections for HOA homeowners who wish to use their property as a landlord, and third, protections that allow for meaningful redress before a homeowner loses their home due to an HOA dispute. So starting first with these minimum standards for HOA rulemaking. My daily work primarily works in manufactured home communities where there are lots of community rules. So that's really where the lens comes in, and I feel is analogous to HOA communities and a great place for Minnesota to, either pull from, has been recommended in previous meetings. So right now there are no set standards for how rules are created and enforced in HOA communities. There can be rules around things when you can use your dishwasher and whether you can have a work vehicle on the property. Those are common things we see. And while these rules exist in a way and are often made to support some people, they may not know about the needs of other neighbors who work nights and need to run their dishwasher at 10 o'clock at night when they get off shift, or who need to have a parking rule that accommodates their disability. So I think that creating reasonable standards for HOAs around rulemaking, similar to manufactured home law, makes sense here. And some really great ones that we use all the time in housing law are prohibiting, rules from conflicting with residents' privacy within their home rights, their freedom of expression, their civil rights within fair housing law. You can do that by requiring 60-day notices before changes go into effect. I always say notice is an important part of your civil rights. So It's not you get a little flyer on your door of your condo saying, hey, look, starting tomorrow, you can't have your work car out in the parking lot, right? 60 days helps people make decisions around that. Requiring that changes have to be reasonable, right? It's not the pet project of a random person, right? And that any new rule that substantially modifies any previous policies could only be enforced against new owners. And here's why I say this. When you buy your home, whether it's a townhome, a single family home, a condo, you're often given a copy of the HOA rules before you sign your mortgage, before you decide that this is where you want to live. And those rules are things that you agree to. What you didn't agree to is something that changes 5 years later. You still have a mortgage on your home, you still want to use your home, and suddenly it's significantly limiting your ability to use your home in the way that you see fit, or decreasing the value of your home that you have put all of this time, effort into making exactly what you want it to be, your largest asset. We also recommend requiring religious accommodation for rules not related to health and safety. It's really important that all Minnesotans' civil interests are protected. And then requiring a 60-day notice for, within that 60-day notice, requiring a comment period. The best rules are those that support the whole community. And I think that that's a way that really structurally adds that piece to it. Those are, that's a big pick list. I want to move a little bit more to talk about the interests of protecting homeowners who wish to use their property as a landlord. So often when homeowners purchase in a community, they may choose to have that be their single family home, and life changes, right? You decide that this is your single family home and now I want to rent it out while I move somewhere else. Maybe I'm going to have a second home and this is now a property I've always wanted to be a landlord, or even, I can't sell this home right now. I need to be somewhere else in another state, but I plan to rent it out until I return. I've seen many different leases HOA agreements that limit how and when someone can choose to be a landlord for what is their property, right? And I think that it's important for the purposes of this conversation to talk about how that impacts the renters, the prospective people coming in who want to rent from a landlord who operates within an HOA. So for example, an HOA homeowner may have limits that say renters have to be 21 or older if you want to rent out your home, or that you have to have lived here a certain number of years before you do this. We have also seen examples where they have minimum credit scores, minimum criminal history background reports that have to be run. And these things, to me, are not indicative of the needs of the community, but are infringing upon the homeowner's rights. A homeowner who will be, having 100% of the risk related to how the home will be treated should be able to decide what's creditworthy and what's not. There should be a prohibition that HOAs can somehow be involved in what creditworthiness is needed for a person, because we know that credit is often a proxy that disproportionately affects BIPOC communities and disabled communities. There's a conversation earlier about SOI protections, source of income protections. I think that that's huge. The Minnesota Human Rights Act protects Minnesotans from being discriminated on the basis of their income. I think that that's meaningless if that means in some communities, but if you want to live in these communities that are, proliferating and coming around, single family home condos, townhomes, you want to rent in those places? No, they have an exception to this rule. I think source of income protections are important and need to be added to this. And then we can't have blanket rental screening requirements. I think that is something that doesn't serve an HOA community and infringes upon the rights of the homeowner. Lastly, I want to talk and touch a little bit about the need for protections to allow for meaningful redress before a homeowner loses their home to an HOA. So if a homeowner is behind on their HOA dues, if a homeowner has gotten a fine from an HOA or is otherwise broken some sort of rule or regulation within the HOA agreement, they could potentially have their home foreclosed upon them. Due to the serious nature and power of these unregulated boards, it's really important that there's some sort of structure around both what the formalities are of these board meetings and also what powers they have. So ideas such as requiring boards to have agendas for board meetings and allow that homeowners have the right to speak at board and association members on things that'll affect them, right? All of a sudden they say, okay, anytime a dog barks, it's going to be a $100 fine. Maybe having a regulation on, dog barking is important for the community, but $100 can be the difference between someone making their mortgage or not. So making sure that the Minnesota Attorney General has regulatory oversight on the state's condominiums laws to enforce HOA's laws and provide appropriate funding. Don't exempt HOAs from following Minnesota laws when they conflict with broader protections that otherwise exist. And then lastly, something that we hear is requiring 60-day notice for fee increases and special assessments. So emergencies are different, we would say that, but often allowing for additional time for notices of fees increases can help people. It makes it so that way people are able to stay stably homed and are not facing a decision on whether to make their mortgage and their HOA special assessment or food. For many Minnesotans affected by these issues, this is the first experience as a homeowner, whether in a condominium, a townhome, or a single-family home. We want to protect the interests of homeowners and provide guidance to these HOA boards to make sure the civil rights of all Minnesotans are protected. Thank you.
Thank you, Ms. Jimenez. We will then move on to our next speaker, and then we'll circle back with Q&A. So please hold tight, Ms. Jimenez. And we will move on to, we have a presentation by Mr. Nick Erickson. He's the Senior Director of Housing Policy at Housing First Minnesota. Again, just a reminder, we'll have question and answer period afterward for folks to discuss. Mr. Erickson, if you'd like to go ahead and state your name and affiliation for the record, and go ahead and proceed with your presentation.
Thank you, Madam Chair. My name is Nick Erickson. I'm the Senior Director of Housing Policy for Housing First Minnesota. You can go on to the next slide, please. Our organization is an industry association of builders, remodelers, developers, and the skilled trade partners that build the communities and places we all call home. And our organization is driven by the mission of homeownership opportunities for all Minnesotans. And you can go to the next slide. Before we go into HOA creation and new construction, I would like to level set the conversation of housing affordability in Minnesota. From a new construction standpoint, we are an island of unaffordability. We have the highest new home median sales price in the region. Right now, we are at $540,000 here in Minnesota. In the Twin Cities Metro, it's nearly $550,000. We are 23% above the national median average statewide and 25% above the national median here in the Twin Cities. In fact, quarter two of 2024 was interesting because it was the first time that Illinois crossed into the $500,000 point. People are kind of surprised by this, but we do have higher housing costs than even in Chicago from a new construction standpoint. Next slide, please. The conversation about HOAs really can't go into too much until we talk about the common property that's required with new construction. So starting at 12 o'clock, we'll work our way around really quickly. Pickleball courts and other public amenities that may be added, chosen by the developer or required by local government that are not managed by the city. Private streets, this is somewhat more common, specific to higher density townhomes, but there's also beneath that stormwater ponds, and then at 6 o'clock, kind of working around clockwise, would be trails. In the center, we do have outlots and buffers, which can be caused to create an HOA when it otherwise may not be required. Center medians, kind of at 7 o'clock. At 9 o'clock, we have townhomes and condos. Because of the structure and how that's common property, they do meet the definition of a common interest community, and that is required by the structure design. Finally, fences as well as monuments at the beginning of developments, and those really monuments have become pretty commonplace since the 1990s. Next slide, please. So there's three main reasons that HOAs are created when it comes to new construction in Minnesota. First is structure design. This, as I said earlier, townhomes and condos because of the shared nature of the structures, do meet the definition of a common interest community. And so you will have an HOA to manage the building exterior and the roof, potentially a shared driveway. A townhome photo I showed did have a shared driveway. The second reason is the target market. This is the builder's choice. And that is something we see most popular with the aging in place community. You may hear those referred to as villas or patio homes. That's really that single level living designed around individuals who really want to age in place with maintenance-free living. So the HOA there is created not necessarily for the structure, but because they're seeking to have some shared services such as snow plowing, trash removal, yard maintenance. And then finally, they're mandated either directly or indirectly from local government policies. Next slide, please. This really comes into two main places. This is either going to be directly because of the zoning requirements, or it's going to be within the discretionary review process. And these do happen, again, directly or indirectly. Directly would be specific call outs in a policy. I think Otter Tail County has a policy where they really want to see HOA created with any new housing. Then for Senator Lucero up in your neck of the woods in the city of Dayton, the R3 zoning district, they really are seeking to have private amenities. This is where the pickleball court comes from. That's one of the options of amenities in that zoning district, to have a private amenity required by the government, but then mandated that this amenity that's being required is being managed not by the city who's requiring it, but by an HOA, thus forcing an HOA to take on management of a private amenity. And then also in Lakeville, their platting requirements for lots less than 70 feet will require a common interest community to be created because of the outlots and buffers that are required. Then with discretionary reviews, I always like to remind people in Minnesota, we don't have zoning off the menu. It's not like you walk into City Hall and say, we're going to do a zoning that conforms with this at a larger subdivision level. In Minnesota, we have to buy zoning from local government through the plan unit development variance. And because of this, in order to get the density required to make a project pencil out, and also to address Minnesota's housing deficit, we're 100,000 homes short in Minnesota, 75,000 of those here in the Twin Cities. So really to close this deficit, we need to be building more homes, which will require an increase slightly in density. So in order to get that density, you have to negotiate with the city. And in this process, they can make a direct request to form an HOA, or could be done indirectly by mandating common property. And then also that common property, whether it's an outlot buffer, maybe a median that's required, then has to be maintained by the HOA. Also, when a common property is already being created, this process can force additional property to be placed onto the HOA and then managed by that, so thus increasing HOA fees in perpetuity. Next slide, please. So you may be wondering, well, if these are negotiations are voluntary, so how does this really work in the real world? 2018, the Minnesota State Supreme Court did find that when this was an impact fee case, the city of Woodbury was charging a fee it was not allowed to charge under state law. But in this unanimous Supreme Court opinion, the court found that when the likelihood of facing a denial of your application due to supposed voluntary terms and conditions is the price you pay for saying no to a city, that really is, it's nothing voluntary about that. So when developers are being forced into these conversations about whether or not they're going to have an HOA, saying no can actually see your project get denied. Next slide, please. I always like to say, HOAs are a tool of fiscal exclusion. The Twin Cities is home to the widest home ownership equity gap for communities of color. Part of this is due to the high cost of housing, but it's also due to the historic use of socioeconomic exclusion in our land use policies here in the state. And I think we've already heard some testimony on that. Don't need to go too much more into that, but if you could go on to the next slide, please. So right now, I just crunched these numbers over the weekend. The median existing home price in in Minnesota is 340,000, and that's roughly again 540,000 for the median new home price. 5% down at today's interest rates, which over the weekend were 7.1. You're seeing median existing home price would cost you about $3,000 a month, just a little less than that, and a little over $4,000 a month if you had the if you bought median new. You add the U.S. median average of just under $300 a month HOA fee, you really do almost add for median existing home price in Minnesota. You're adding a 13th mortgage payment a year just on this median average price. And obviously HOA fees ebb and flow based on the needs of the community, but just try to use the U.S. average here for comparison. And then you're paying almost a 13th mortgage payment a month or a year if you're buying the median new price. So these really do have an impact on affordability. It's important to remember that when you are getting a mortgage, it's principal, interest, taxes, and insurance. And that's all levied against your ability to pay your mortgage based on your income to debt ratio. However, when you do have an HOA, those HOA fees are part of that calculation. Next slide, please. And because of that, today's interest rates, they do reduce purchasing power. And that U.S. median HOA fee of roughly $300 a month will see a $36,000 loss in purchasing power for the individual. And that's because at 7% interest, every $100 a month that is being assessed in a HOA fee will reduce the purchasing power of the home buyer by $12,500. And that's based on, just average U.S. numbers at today's interest rates. And obviously that number does change as rates fluctuate. Next slide, please. Other challenges we see with HOAs from an affordability standpoint. So number one, HOA fees do increase over time. There's not that expected consistency you get with a non-HOA mortgage payment. Also, the lack of maintenance can lead to significant assessments. We've seen this part of the legislative agenda back in 2017 was to address the lack of maintenance in common interest communities by requiring that HOAs actually maintain common property so that they can't file construction defect lawsuits against builders and developers. That law was partially changed. I think there's still some work that needs to be done, but the lack of maintenance can lead to significant assessments. And when those assessments happen, as we've seen in Florida, owners are forced to potentially sell their homes or condos because they are not able to afford the assessments because the lack of maintenance has gone on for decades. Also, the insurance market right now is volatile. I think we all see that. But the specific to townhomes, it has gotten, and common interest communities, they're seeing significant increases on insurance rates for common interest communities. Now, when insurance rates go up through the HOA, that's going to increase your HOA fees. And that's for existing. Insurance side right now for new townhomes, which are the most affordable product and the product that we can deliver closest to under $400,000 here in the Twin Cities, getting new insurance on townhomes right now is incredibly difficult because insurers are very risk adverse to insure an entire development. So that a lot of effort, time, and energy, in addition to the money, goes into trying to find insurance for some of the common interest communities we are adding to the state at the moment. There are also significant concerns about offloading the maintenance of what should be public infrastructure onto the backs of HOAs. And this is because of the lack of maintenance will in coming years could increase significantly the home prices or the HOA fees in these communities. And then also there's a significant property tax overlap when you have some HOA. So for example, if you were to live in an HOA with private streets, when the private streets are required by local government, you are still paying the same property taxes as an HOA that doesn't have, or as a townhome that doesn't have private streets. Yet your private streets are, you as the HOA are responsible to plow those streets. You're responsible for the maintenance of the streets in perpetuity. So there are some concerns there as well. Also, I will add, I think we've heard some testimony on, kind of the standards that these HOAs have. I will say that, what we've seen in the new construction space over the couple of years is that these are really reducing property rights of individuals. As the state has had some discussions over the use of luxury material mandates that local governments are imposing on new construction in the state, some communities have asked instead to codify those requirements into the covenant of the HOA, so that if the state does get rid of luxury aesthetic mandates on new construction, that those requirements are still codified into the HOA's requirements. And that really does reduce the property rights of the individual, because there was an HOA now gets to choose what their home looks like, and not, frankly, the property owner. Next slide. Just a few examples that we have heard from our members on the formation of HOAs. And I just want to add that our members are happy to do HOAs when it's required and when they see a need in the marketplace. But right now, because of the significant affordability pressures and the challenges with HOAs, our members are seeking, when possible, to not do them. The problem is that these requirements are usually coming in the form of the negotiations as part of the housing approval process. And some of these requests that have been asked over the last couple of years as we've been following this issue is requests that a homeowner association not just be formed, but you join an HOA of an unrelated subdivision. So you would have one subdivision with its own wholly contained neighborhood, and then a new subdivision would have to join that HOA because the municipality likes that HOA better. That's really not, in my opinion, a function of government. Another one very common is to form an HOA to manage outlots. So instead of having, if you require outlots and buffers, you would then have those owned and maintained by the HOA. And I'll give you one example. We had a developer member of ours who was requested that they form an HOA to manage and own some outlot buffers between two subdivisions. There was no reason for an HOA to be formed in this city, in this subdivision. And so what the developer did was tell the city, well, we're not going to form an HOA. There's no need to do that. So instead, the city required that they line up these outlots to be in accordance not with the new subdivision whose backyards this was, but instead with the new property or the existing property owners. And then those outlots were conveyed to the city free of charge, and the city then sold those outlots to the existing residents for $1. So you actually had property that was paid for by the developer, cost passed on to the new home buyer, and then city sold that land for $1 to existing residents. HOA management of required infrastructure, we see this a lot. It really comes up with stormwater ponding, probably most significantly. And I firmly believe that a municipal staff is far more equipped at managing our stormwater systems than our HOAs. Another really good example, we had one where lawn sprinklers were mandated within an entire subdivision.
Mr. Erickson?
Yeah.
I just want to make sure that we're clear that we're getting close to time. Are there any additional slides or things for the presentation? I just want to make sure we have plenty of time for folks to ask you questions.
I'll just do this last example. So what we really see here on townhomes when it comes to the private streets is we have situations where some communities will say if you have required streets, or if you have private streets, it has to be private sewer and water under there. So now we have private arterial line coming off the main that is now owned and maintained by the HOA, again, who I don't believe are equipped to manage municipal sewer and water system. So what you end up having is a developer will have to choose, will we have a reduction in density and a reduction in the number of units, which will raise the home prices in that subdivision, to have wider streets and a municipal managed water and street system, or will we put that on the backs of our buyers and then get the needed density and lower price points, but then have them pay higher HOA fees. So there really is a significant choice that developers face with these private street requirements when it comes to private sewer and water. So I'll just leave you with that, and I'm happy to stand for any questions.
Thank you, Mr. Erickson. With that, I'm going to quickly try to open this up to the folks. We're running a little short on time, but I want to make sure that if folks, members have questions for either Mr. Erickson or Ms. Jimenez, that we can get those questions answered here before we take a brief break. Any questions from the members? A quiet bunch today. Vice Chair Lucero.
Thank you. Just have one question. You may have said it, and this is for Mr. Erickson. And if you said it, I apologize, I missed it. Same question I asked earlier in the week to Mr. Lightfoot is, do you know of the new developments that are being approved? Do you know what percentage are PUD?
Yeah, Senator Lucero, great question, Madam Chair. The percentage, really within the Twin Cities, it's closer to, if you look at a 5-year average, it's really up, I'd say by unit count, closer to 85, 90%. I always look at it as unit count, not developments, because a single development with 10 units would then count the exact same as a development with 500 units. So I always try to do unit count, and by unit count, it is, I would say 70, minimum 75, but definitely closer to 85.
Thank you. And Vice Chair Lucero, could you, just in case folks are not familiar with the term, point out what PUD is?
Thank you, Madam Chair. I'll actually defer to Mr. Erickson. I actually use the acronym so often off the tip of my head, tongue here. I'm forgetting what the acronym stands for.
Or Mr. Erickson, because we do have a lot of members of the public listening in who may not be familiar with housing terms. So I just want to make sure that we're outlining what that means for context.
It just came back to me, planned unit development.
Planned unit development. Thank you. And then we have Member Berggren with a question.
Sure. So I think I understand what you're saying, and see that. I work for the city of Bloomington, and most of the way that development happens is if a developer chooses to do certain things, then that triggers the requirement related to having a entity that manages the privately held item, whether it's a amenity or shared land or actually a building that needs collaborative ownership. So all of that makes sense. And I think the example, I call that like they're all if-then situations. If this happens, then that happens. And that the requirements that cities impose are not, there's always that if that's part of the requirement. I think the examples you shared would fall into that category too. So what I'm struggling with and wondering is if there's ideas around other ways that these privately held shared things could be managed. Because that's the whole kind of point of having these HOAs, is that they're private. Like there's a development that has a swimming pool and somebody needs to manage it. Therefore, this HOA gets created to manage this scenario. That's just, I think, the types of examples that we see most often. There may be a few one-off examples where HOAs get created when they're not needed, but I think for the majority of the time, it's because there's a shared amenity or a shared feature that needs collaborative ownership.
Right. Ms. Jimenez, any thoughts on that particular question? If not, I'll hand it over to Mr. Erickson.
No, I don't have any thoughts on that.
Okay. Mr. Erickson?
Yes, Madam Chair, and I will just say that the industry has no problem with mandating the private amenities when they choose to install them. The question really comes down to who is requiring these amenities, who is requiring that private infrastructure like stormwater ponds or public infrastructure, stormwater ponds be turned into public infrastructure? Who is requiring, like in the city of Dayton, amenities in a townhome? These are not required by the developer. Our members do not want to do shared amenities and private infrastructure via HOAs unless it makes sense from a target market perspective. And right now, I just talked to several of our largest developers, and they say right now they're avoiding with any at any and all costs to do an HOA. What we're talking about here is the question is who's managing who it really needs to go to who is requiring this infrastructure to be created in the first place. And if it's not the developer, these are requirements being added by the municipality as part of the approval process. I think the best solution is to not force the creation of HOAs or common property in the subdivision approval process. That is the shortest answer. And then do as we do today. If it really is a true request by the developer or a requirement because it's a townhome or condo, have the HOA, but let's not make this the minimum construction standard in Minnesota.
Thank you, Mr. Erickson. With that, I'm going to go to Member Daly.
Thank you, Chair Bonner. I have a question for Mr. Erickson around that same topic, basically. I'm just trying to get a handle on sort of the whole scope of this. And to be frank, I'm a bit shocked to hear that there's municipalities that are mandating private amenities like pickleball courts. That just seems absurd why a municipal government would mandate such a thing. And my concern really revolves around this whole idea that then these sorts of private amenities then lead to costs that are passed on to the homeowners, and then a homeowner can't pay, and then people are losing their homes over these luxury sorts of recreational. So I just don't get that at all, why any government would do that. And so I'm trying to get a sense of sort of how widespread is that? And then also, to what extent do municipalities require HOAs when it's just something like roads? We need this amount of new roads, which, as you mentioned, would also then require the sewer and, water runoff systems. Do some municipalities say, well, even if the only thing that you're needing to do is put in new roads, you need an HOA. We're not going to pick up new roads. You need to pick that up. Like, to what extent can municipalities just say, no, that's on you? That's basically my question.
Mr. Erickson.
Madam Chair, Member Daly, yeah, so that's a good question. So the roads are really more on private streets. They are, and I'm trying to be short on time, so I didn't explain it completely. Those are usually when the roads are more narrow than is this traditional standard. New development pays for all infrastructure. It pays its own way and then some. New home buyers pay for streets, sewer, water, stormwater connections. All of that gets paid for with the price of a new home. Most times this infrastructure is managed by the streets, sewer, water, all that managed by the municipality. Stormwater is the area where we do see municipalities trying to offload the maintenance of stormwater ponds onto home buyers through an HOA. And also when they're mandating the amenities, really this comes down to what I call fiscal zoning. We are using our zoning controls in our communities to increase the cost of housing, to exclude people based on socioeconomic status. That might not be the intent, but that is the outcome. When you raise housing costs, you decrease housing access. So dollar for dollar. Right now in Minnesota, every $1,000 that's added to the price of a home will price out about 2,200 people. And that's not just that's the home price. You can also price people out by having HOA fees. I did go over that on a slide. The problem is our approval process on new housing in Minnesota is fundamentally broken. We are the most reliant in the country that I have seen on HOAs. My good friend at the Mercatus Center at George Mason University says we're the land of 10,000 PUDs, which is kind of a play on 10,000 lakes. But he says that zoning is fundamentally broken in Minnesota because we rely on the discretionary approval process and variances. It would be like if every time you went to McDonald's, you had to design your own hamburger and they could charge you whatever you wanted, or you designed your own value meal and they could charge you what you want. That really is how zoning works today in growing communities, which is unfortunate because this is why we have the highest housing costs in the region from a new construction perspective.
Thank you, Mr. Erickson. And just a very brief answer here, but are you seeing where there are arrangements with cities where they agreed to pay for the upfront cost of things like sewer or roads, but that there's a timeout period in which the city will take that over? Because I know there was a discussion earlier that they're really not made to handle things like sewer maintenance over a long term. So just curious if you have seen that arrangement.
No, Madam Chair, I have not. So how it really works is, usually there's some maintenance, there's some systems that are built, like main lines get built out early, arterial roads get built early. I mean, in some cases, I live just off Robert Trail. That road has been there for, really since the Twin Cities region was settled. So you get these roads that just exist. It's really the in-development streets and sewer are added. Sometimes it's added by the contractor of the municipality's choice, other times by the developer. But the in-development streets, whether they are public or private, are generally added by the developer, paid for by new homeowners. Same for the in-development sewer systems, stormwater, all that is added at the time of development, and that cost is added to the cost of the home. In most situations, not just in Minnesota, but across the country, that new infrastructure is turned over at a certain point in time, usually when that phase of development is completed, turned over to the municipality, and that becomes municipal property free of charge, and it is then maintained by property taxpayers because it's municipal property. What we're talking about is when it's instead forced to become the HOA and then held, for really in perpetuity. I have not heard of anyone coming to an arrangement where they've been able to take it back, or maybe putting it on later. I'm not familiar with kind of a timeout of any of that.
Thank you for that. We have one more question and then we want to take a brief break. So I'm going to let Member Taylor ask her question and then we're going to head to a break. Member Taylor.
Thank you, Chair Bonner. I actually wanted to add context to this question, if that's okay, for Member Daly.
All right, Member Taylor.
So one of the other things tying back to what Ms. Timinus was talking about that I think is important here is that HOA communities in general average a 4% premium in the nation on their home prices. So that also leads to higher property taxes, right? And so having homes that are bringing in higher values on resale means that they're having a higher property taxes, which Mr. Erickson is, talking about with these communities of fiscal exclusion. I think the other part of that is that because of the formation of HOAs as racially restrictive communities historically, even though racial covenants are no longer legal, requiring HOAs still does serve as a modern day racially restrictive covenant. And that is the impact of them. So you are developing racially exclusive communities that the cities are mandating in this way by requiring so many HOAs, because studies show that people that live in HOAs are predominantly whiter and wealthier than non-HOA homes on average. And so they're likely to be disproportionately more likely to be white and Asian and less likely to be any other race. And their incomes are disproportionately going to be higher. And so, we do have to look at some of the structural impacts of why HOAs were mandated in the first place historically, to see why, even though it might not be an intentional thing now, that is built into the structure of our housing system. And so continuing to mandate HOAs is another way to make the population of an entire neighborhood across these cities and to create these exclusive communities across these cities. And as Mr. Erickson talked about, to have this double dipping by cities to say, we're going to take the same amount of property taxes, but it reduces our burden to you as the taxpayer, because we're not going to have to maintain any of these areas that we would normally maintain as the city. So I just wanted to add that context, that I do think it's a major issue and it serves as an equity issue, what we're talking about today, because it does, mandating HOAs in this way does serve to continue to segregate Minnesotans in a really, really profound way.
Thank you, Member Taylor. I do want to just point out that in technicality, they are not mandating. I realize that's sort of the practical effect of what's happening, that it appears that this is what it's doing, and sort of the unintended consequence is that we are in some fashion discriminating, and that is what I think the numbers bear that out, and so we want to be honest and upfront about that. But I just want to be careful that legally we are not. There is nothing being mandated. So just making that distinction. So thank you, Member Taylor. With that, I'm going to call a recess. We will come back at 11:35. So we'll just give it actually 9 minutes for everyone to take a brief bio break, and then we will come back to have our final discussions. And with that, we need to take a recess. Do I have anyone to provide a motion to take a recess?
Motion.
Thank you, Member Murray. All those in favor of a brief recess of now 8 minutes, please say aye.
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 All right. Any
Aye.
opposed? All right. We are in recess till 11:35. Thank you. Ms. Pollock and Mr. George, I know in the agenda we did not mention that we probably actually need to have a brief moment to see if there are any new recommendations based on today's presentations. We should probably cover that first before we dive into the rest.
Yeah, can you repeat that for Miss Pollock?
Yes, Ibra, I was just saying that in the agenda, it doesn't mention anything about if we have any new recommendation based on today's presentations. We should probably get that first while it's fresh on people's minds.
For sure. I have the screen ready to share.
Okay. All right, with that, we are back from the break, and I know some folks will saunter in as they come back, but we will go ahead and get started. Do we have any members first that have recommendations? Otherwise, I know I've highlighted a couple that I can try to reach. Senator Pa.
Thank you, Chair Bonner. So, from what I've heard, I'm wondering if there are some cities that are requiring amenities that would then trigger an HOA to be formed. To that point, I wonder if there could be a prohibition of some sort that would address it. The cities cannot, cannot require that there are certain amenities in a development that would then require an HOA to be formed. And so I don't know how that may look like, but that would be my suggestion.
Thank you. All right. Member Daly. Member Daly, you're on mute.
Sorry, I apologize. Yes, I just want to reiterate that suggestion in terms of, I think to the extent we can, I mean, this really starts to venture into zoning law, and I don't, if it's beyond our purview, I don't know. But I think that some sort of restriction on municipalities to not just require amenities, but require HOAs at all. I mean, obviously, if the developer themselves is proposing this commonly owned property that there's common, then there has to be an HOA. I mean, I don't see any way around it if it's part of the developer's plan. But for the city to ever require that when the developer doesn't even want it, that feels to me like really something we should prohibit if we can, because it's, from what I'm hearing, it sounds like that is increasing the cost of homes, and it is pricing people out, and really unnecessarily. I mean, I don't see any reason why these new developments should have to have the private individual owners take up things that should be, the responsibility of the municipality. So not just requiring amenities, but any requirement that an HOA is formed unless it's obviously necessary because of something in the developer's plan.
I will just say, and staff or maybe the lawyers on in our work group here can correct me if I'm wrong, but I don't think that there is anything that any specific things that require cities to or there's nothing in the law that says you have to create an HOA or offer specific amenities. But Vice Chair Lucero, did you have a comment on that?
Well, I appreciate this. And so you are right. I don't think that there is anything in the law to that effect. But what's happening is, in my experience and from communications I've received, that municipalities have requirements that necessitate the formation of an HOA. They have a requirement, as we saw in one example, the pickle court, or any other shared or community feature or asset. And so, and to Senator Paz comments and Miss Daly and others, so there I did have language that it reads, it's almost verbatim. Municipalities cannot have requirements that necessitate the formation of an HOA. So it's not speaking, it's not prohibiting the formation of an HOA, it's prohibiting requirements that require an HOA. And so I think it's very alarming when we saw the statistic from Mr. Erickson that a high percentage of new construction units are via a planned unit development, because that is the avenue by which these municipalities are subjectively having these requirements that then necessitate the formation of an HOA, rather than the alternative, which would be zoning. So if they know upfront what the requirements are going to be, a developer can seek if they want to adhere to those requirements in zoning, versus the subjectivity of a planned unit development. They don't necessarily know what the requirements would be going in a concept phase. And so I have no problem with the market driving any kind of amenities, whether it be pools or parks or trails or etc. But if it's the municipalities that are requiring these amenities that then necessitate the HOA, that's where I have a huge problem. So very, very appreciate this conversation.
Thank you for that. And I think we had touched on this before, but I don't know if we officially added it to the recommendations, but there was a earlier topic that talked about this idea that cities should be required to consider the sort of percentage of overall housing that, or some makeup of housing that explicitly does not require an HOA versus those that do, and how that impacts their overall development planning for the city. Because I think when we talk about affordability, we want to offer a range of housing options for folks. And certainly we don't want to say that you can't have HOAs. That certainly is the right of certain developments, but certainly have that be a thought in the planning process might be a good recommendation. There was also one I wanted to call out just before we move to Member Cole. Or maybe two. And I think they may be out of scope for us, but we may want to consider a recommendation on researching these particular topics. The one is there was a considerable conversation about driving up costs and delays and how permitting has an impact on that. So perhaps the research request would be that perhaps we may want to study the challenges around permitting to see if there's a way to decrease those barriers that might increase cost. And again, that might be a little bit out of scope technically for our group, but it certainly may be something we would want to push to recommend researching or looking into. And the other was also another research topic would be researching the parking restrictions and how to balance both the needs of folks with disabilities against those for perhaps a lower footprint to bring down costs. And, I don't know what that balance looks like, but that might be something worth researching, how to do that in an equitable way to ensure that we are being both compliance for folks with disabilities or our elders, but also making sure we can bring down costs. So that, and Member Cole, you had a recommendation.
Yes, thank you, Chair Bonner. I would love to see somewhere in this where as cities or whoever is creating this HOA situation to be accountable for what they are doing. I have heard so many times from so many city councils that we don't get involved in disputes between neighbors. Well, but you created this neighborhood, so why aren't you caring how it's run? Why aren't you caring what is going on with this. This is you did this, so how do you get to do the dump and run? Um, I would love to see that be addressed somehow, somewhere, of making the decisions justifiable, that, if we need this, then what is the role and the responsibility of the city, rather than doing this dump and run on the homeowners.
And I just want to be clear. I mean, this one is a challenging one in that, they are not technically requiring it. That may be the practical effect of the approval process, but they're not technically requiring it. So I'm sure our lawyers could speak to this, but it's probably a little bit challenging to nail that down, because technically they really aren't requiring it. By an ordinance or a statute or a legal mechanism. That is the practical effect of it. But I think, and we might need to talk about that in other ways. And I think Vice Chair Lucero suggested some wording up above that might in a roundabout way come at what you're saying, Member Cole. But we may have to revisit how that would work out practically.
Well, and I agree with you on that, but somebody else had brought up that the if then, well, if they are wanting this as part of their contract, then they have to be responsible for how it plays out. If they want the HOA to be established, then they have to include some rules for managing the HOA that are consistent with the policies of the city, the ordinances of the city. If they want this to happen, then they need to be part of the relationship and be accountable for what happens.
I will just say, I don't know that we want cities, though, to be managing HOAs per se. I'm not sure that's their role. And I'm pretty sure if we talk to the cities, they would adamantly run away from that idea.
Oh, well,
But
and they are running away from it, and that is part of the problem. They are doing this dump and run thing. They're setting it up, and then they don't care whether or not we have a audited financial report. They don't care about how
Member Cole, I do want to move on to the next suggestion, but I just want to say, I do want to be very clear that I think part of the reason that we are here in this work group is to discuss how we put those guardrails in place and what that looks like, and how we might do that legislatively across the state, so that there are specific standards, rather than having cities determine that on their own. All right, I'm going to move on to the next member, Representative Meckland.
Thank you, Chair Bonner. And I don't know, it just kind of sparked by my mind from the gal that did the presentation for housing justice, whatever it was called.
Yeah.
So I have 5 of these HOAs that all have a municipal septic system. All 5 of them were sold to an investment firm out of New Jersey, and they now all 5 are non-compliant. So each one of these homeowners just got assessed at anywhere from the low 20s to the upper 20s and thousands, and they've only been given 3 years, of which has already put 2 of the homeowners in position where they cannot make their payments, because it's like an additional $900 a month. If there's something that can be thought of, because they're not eligible for any grant money, any state money, anything anywhere, because they don't own it, some other company owns it, and it's just a very tricky mess. But this 3-year thing, it seems to be pretty aggressive at that level, because of obviously the steep monthly price, and furthermore, they have to pay this to a company over 3 years and hope that the work actually gets done. To which it surprises me that it wouldn't be more proper to put it in like an escrow account, so that ensures the work gets done. But if we could add something like that to the suggestions. Thank you, Chair Bonner.
So, Representative Meckland, I know there was a conversation earlier about using HIA or the Minnesota Housing Funds to finance items to make it more affordable in a more similar way to how we might spread out payments for, say, assessments for a road replacement for standard family homes that are not in HOAs. Is that sort of along the lines of what you're thinking?
So yes, to a certain extent. My concern is though, so these systems were all sold by the previous company, knowing that the MPC had already deemed them non-compliant. And there was a reserve fund built up in at least one of those associations that should have been somewhere just north of 200,000, which that does not exist anymore. I would have reservations about like the program you're referencing, where now you have this investment firm throwing on a dollar amount. They apply for this to spread this money out, but the accountability to make sure the work actually gets done. This they don't just sell this whole thing out to somebody else after they've collected all this money. And there's got to be some guardrails into this stuff.
Okay. So, and I think we should talk about that as also some guardrails around the fiscal responsibilities of property managers and boards. And I think there might be something up earlier in the discussion about that specifically, but I appreciate that suggestion. Member Daly.
Thank you, Chair Bonner. I just wanted to respond to something you had just said about thinking that the municipalities were not requiring these HOAs. I'm hearing from at least Mr. Erickson that they are requiring certain things that then necessitate an HOA because it's commonly owned. So
Just to be clear, I'm saying they aren't legally, or there is no specific requirement, but the practical effect of the approval process is that they are in fact to some degree requiring these things, even though it's not explicitly stated. But that is sort of the practical effect of what they're doing. Just to be clear.
So you're just saying, you mean they don't, it's not in ordinance that they must have an HOA? Oh, sure.
Correct.
Sure. But yes, they're requiring it as part of their zoning permitting processes.
Yes. Yes.
Practically.
Absolutely.
Well,
okay, point well taken. And if I did not state that clearly, thank you, Member Daly, for correcting me. I appreciate that.
Sure.
All right. Member Murray.
Yes. I had actually three suggestions. After discussion from previous one of our previous listening sessions, I'd like to see steps taken to make sure HOAs have the resources to meet or exceed access ADA and I'm forgetting the web accessibility standards when they are providing notice and materials. So everyone is receiving materials and notices in the languages and accessible means. And then my other two suggestions would be we have a social return on investment study for HOAs to calculate how beneficial they are and who is, I guess, where is the money going here? From how I had been listening to, I'm forgetting Nick's last name, but like how people
Erickson?
were passing the costs on effectively to the homeowners sounded very reminiscent of racketeering. And that addresses the other representatives' concerns with like we are passing large amounts of money to resolve these issues created by investment firms for their benefit. So I think we need to have a map of how these entities often are benefiting so we can properly address them in law, because otherwise they're going to find up other loopholes. And then we also need some sort of remedy so that venture capital firms don't always win because they have more money, because otherwise they will. And then I'd also like to see, I gave Andrew a link, but a sludge audit for the homeownership process and the building process, because we've heard consistent feedback that we have mismatched, from how plots are created to how zoning, like we have to buy our zoning, to like notices, like home ownership is a huge burden on the citizens of our state, and it doesn't have to be as burdensome as it is or take as much time as it does. So let's map it out, and then it sounds like there's so many resources available. Um, let's start encouraging people to use them. And like we already have shared purchasing cooperatives for the state of Minnesota. Let's see if we can leverage those. Okay, thank you,
Thank you,
Madam Chair.
Member Murray. I appreciate that. And then Member Kimball.
Yes, hi. I just wanted to clarify a little bit the recommendation that member it scrolled down now, so I can't actually see it, but the one that has to do with cities not unduly requiring amenities that result in an HOA. I'd like to just clarify that point a little bit or offer a friendly amendment. I think we want to be careful that when it's detached single family home developments, we wouldn't want to require things like swimming pools or tennis courts or other shared amenities that drive up costs. But when it's an example of dense development like twin homes or condos or townhomes, we certainly wouldn't want to discourage that type of development. That's smart land use. It results in more units of housing, and it's something that actually keeps costs down. So I think it's important to just sort of make a distinction between the types of requirements.
Thank you for that, Member Kimball. Do we have other members with items that they wanted to put on? I did want to note that one of our presenters had mentioned the possibility of talking about a requirement around particularly around rental properties and having no specific rental rescreening requirements, that could screen out folks who maybe are lower income, who may be folks with in communities of color, or folks with disabilities, and or things like that, that might be something we want to entertain. There was also they did mention, and we sort of talked about it here, but we may want to consider adding some protections around source of income. We talked about discriminatory covenants covering things like race, uh, uh, religion, etc., but we did not talk about source of income. That was brought up as one specific thing that we could potentially do as well. And then there was one also that I think covered religion, but now I'm not seeing it. But that suggested sort of practical ways to address religious requirements that would allow for that to be observed without impeding the rights of individual homeowners. No matter what your background is. And Member Taylor, did you have a recommendation you wanted to add in?
Yeah, since you were thank you, Chair. Since you were filling out the ones from Ms. Taminis, I wanted to talk about the source of income one that was actually recently passed statewide in Texas. And the rental screening requirements, both of those are so important because they serve to restrict certain people from entire neighborhoods, right? Because you're having now HOAs in entire subdivisions over. So if you're saying no felons, you now are saying no felons in this entire neighborhood, nobody with a voucher in this entire neighborhood, not just a unit or potentially a property. So that's why it's super important there. One of the recommendations that I heard was around reasonableness standards of rules. And we talked about, I think I brought this up earlier. This can really be based on existing Minnesota law and manufactured home law. Because a lot of the like internal discrimination happens in the rulemaking process, in the governing documents, as well as some of the governance and accountability pieces. Like some states have mandated that people are able to speak during board meetings, which Minnesota does not have that, right? Mandating appropriate notice for changes, fees and fines that are coming up, increases, assessments, etc. Just wanting to make sure we capture that as well. And
And
then finally, for some of the civil rights stuff, having the Attorney General's office have some enforcement around that as well, or
yeah,
around condo law.
thank you, Member Taylor. I just wanted to point out, I think the specific recommendation around fee increases was a 60-day notice
Yes.
from the testifiers. Was just for the record, if Ms. Pollock wants to record that.
Thanks, Chair Bonner. Would that go under the recommendation or the notes?
I would say put it under, well, we may want to, it's basically around fees, but is the actual topic. But I'd say we want to make sure that there's a 60-day notice around fee increases.
As well as special assessments and
Oh, yes.
yeah.
Sorry, I was lumping fees together with as an umbrella term, but yes. All right.
Thank you.
Member Daly.
Thank you, Chair Bonner. I just wanted to, this isn't very substantive, but trying to understand the where we're going from here. I thought the Mr. Horvath, I think it was, his presentation was very brief, and I really didn't have a chance to absorb it all. But it felt like he had some pretty good recommendations that are actually sort of, academically studied and underway, at least in Washington and maybe other places. And are we, like, next week, we're still open to recommendations, I'm assuming?
Yes, we certainly can. What I'd like to do is, and I had hoped Mr. Horvath could go a little deeper on some of those. So we may have to actually go dig into his presentation and see if some of those can be pulled out for our purposes, since he didn't go into them with much depth. But I think he did suggest specifically that we may want to consider adopting the new Uniform Law Commission's latest version. Ms. Pollock was one of the items there that he suggested. And then
he also talked about punitive damages for sort of
yes, he did
HOAs
mention
that are outwardly, intentionally.
He mentioned punitive damages for willful disregard of statute. And I know willful is probably a bit more of a legal jargon, as I'm sure Ms. Howard can attest to. And he also made a recommendation around reasonable attorney fees.
Yes. I mean, we already have that in statute, and Representative Bonner, just to remind you, I am an attorney as well from Legal Aid.
Yes, yes.
But yes, that is already in statute, where if the homeowner does sue the association for them, not enforcing the rules correctly, or there are attorney's fees awarded to the winner of that. So if the homeowner prevails, they do get their attorney's fees paid for. But the risky part about it, I think, is some of these rules are kind of unclear. And so it's very risky for a homeowner to say, I'm going to bring the association to court, because if you lose, then you pay their fees. So it's a very risky proposition, the way the law is currently.
Yep. Thank you, Ms. Daly. And sorry for the
Madam-
misstatement there.
Madam Chair, and
Mr.
real
George.
quick, Madam Chair and members, Mr. Horvath's presentation and supplemental written materials with those recommendations have been posted to the website. So we can comb through those and add those recommendations to this sheet, but also if you'd like added to the report. Thank you.
Thank you so much, Mr. George. With that, Member Howard.
Thank you, Chair Bonner. I really just wanted some clarification on the recommendation around the source of income protection, because the Minnesota Human Rights Act already includes that as a protected class. I'm not sure what we're recommending here, given that it's already state law. It's not within the Minnesota Common Interest Ownership Act. It's under the Human Rights Act, where I think it belongs. So I'm
Is
just
not,
unclear what we're
oh,
looking,
sorry.
what the recommendation is there.
So, Member Howard, perhaps what we need to do is suggest on that recommendation that perhaps we need to review that the Human Rights Act to see if that those protections adequately cover homeowners in this situation, or if there is some need for a supplement, but that may already be established. Thank you for that call out. I appreciate that. All right. Member Murray.
Thank you, Madam Chair. I was seeking clarification for who the damages would be awarded against for the willful, like when you have willful disregard and you meet that standard. Is that being imposed on the association, or do we want to impose that, like, if it is a willful act of discrimination, I would encourage us to consider having at least a portion of that awarded personally against people who are committing those acts. Because I think that means they aren't essentially embezzling from every other homeowner for their willful acts of discrimination or violations of the law.
And I will clarify, I believe the testifier was specifically speaking with regards to boards or property managers.
Yep.
In specific on that particular one. Thank you for clarifying that. Member Taylor. Okay, the hand went down. Member Cole.
Oh,
Thank
I
you.
apologize. I wasn't unmuted.
Oh, I'm sorry. Member Taylor.
That's okay.
Go ahead. And then we'll
Thank
get
you,
to
Chair
Member Cole.
Bonner. I just wanted to clarify around source of income protections. A case in 2010 called the Edwards case exempted housing vouchers from source of income protections. The Human Rights Department has actually been trying to pass a statewide source of income protections because of that. So housing is not covered under the human rights law source of income protections right now. And that is why it would need to be added to provide that coverage. It is not included in the way that it is able to be enforced at this time. And that is why it has been at the legislature for the past few sessions.
Thank you for that. That's why I appreciate the diversity of our members here. We have lots of folks able to contribute on the fly and add information here. So I appreciate all of that from both Member Taylor and Member Howard. Member Cole.
Thank you. I would like to have some clarification around the attorney's fees and who pays the attorney's fees. I know in the courtroom, if the other side prevails, then the homeowner would have to pay the fees in that, but yet the attorney is being paid out of the dues from the homeowner, the association anyway, so it is kind of like this double standard of the attorney gets paid regardless. And so I would like to have some clarification around that. And just a comment that to bring it in line with federal law does allow for individual board members to be held accountable. They can't hide behind the association for misconduct. So it would be in line with federal law to have that, to have the what Member Murray was talking about, to make sure that the individual board members can be held accountable.
I believe that may be the case, but I do think, if I'm understanding correctly, that there may be certain liability protections that are put in place to actually shield individual members from making mistakes. But I think the distinction that in one of our recommendations was about willful versus not necessarily making a mistake. And so I think that that kind of plays out into what you're speaking to here as well.
Right. If there were guidelines or some sort of rules or policies for them to follow, yes, and it kind of goes back to a long time conversation that we've been having, that everything is hit or miss, or they can make up things as they go along. So it's really hard to have that willful standard. And so we need to have a standard of conduct to have that accountability. But once they miss that accountability, then yeah, it is the individuals who need to be held accountable.
Yeah. Thank you for that. And I do want to mention, though, that I mean, when we talk about creating statute, we do have to often refer to very specific standards to sort, or what it applies in best practice, so that we can distinguish, and also to limit litigation. We certainly don't want to clog the courts with unnecessary things as well. So there's often, the courts often do like to have a very specific standard, or an objective measuring stick, if you will, for them to be able to apply the law. So I know that's where things like willful often come in. So in other words, trying to make sure that we're measuring everyone with the same standards. With that, Member Zawadzki.
Thank you, Chair Bonner. I wanted to just go back to the 60-day notice requirement just for one moment. I believe that a long-term notice, when applicable, when we're able to, is absolutely the way it should be. However, from an operator standpoint, there are many situational items. I'll give insurance renewals as the most recent one, where the building needs insurance. The underwriters aren't providing quotes until a week before renewal. And sometimes the associations don't have the money. So they have to look to their membership to get the money. I would like to see us debate or have a conversation around a carve out for those types of situations, for emergency situations. But I do believe 60 days is good for like annual budgets and so forth. And where you know of an expense, that's perfectly acceptable.
I think, Member Zawadzki, that's probably in line with the earlier recommendation around emergency issues that we had discussed in a previous conversation, where that might be sort of a separate situation, and what that would look like, and what would be the determiners around what constitutes an emergency. But I agree with you. There may be some cases in which there 60 days might not be practicable, but certainly wherever humanly possible, appreciate that we might want to do that. Member Butler.
Thank you, Chair Bonner. I've been kind of like sitting down, kind of puzzled by the whole affordability thing. And I think key things that cause more expenses for the HOAs is that need for the reserve and the inability to control the frequency of increase and how much of an increase we have. And I think the things that the HOA is responsible for charging for, like garbage, I just think about townhomes, garbage, sprinkler system, snow plowing. Those are things that single family homeowners have to do, but don't have a HOA that's governmenting that, right? And so when we talk about common areas, you know, even for commercial properties, it's like, I feel there's a lot more things that the HOA needs to take into account for, and even the insurance, right? Single family homeowners are responsible for their own insurance, but is not something a HOA is required for. And I think that helps to make insurance more affordable for the single family homeowner versus townhomes. You have a HOA insurance policy, and then you have an additional personal policy. And so there seems to be a lot of double taxation when it comes to a townhome versus a single family home. And when we really want to talk about affordability, look at the things that we're forced to pay for every month through a HOA versus a single family homeowner. Right. So I would like us to really address removing some of these things that we're putting into the HOA to cover as a collaborative or collective versus some of these things can be individually covered by the homeowner.
It sounds like you're actually kind of striking at the heart of the earlier recommendation about not forcing requirements that would necessitate an HOA, for example. So where it's not required, you don't necessarily need one. And how we encourage cities to not create those requirements as a contingency of approval. But I also understand there may be some communities who want to share their garbage collection or snow removal or whatever. So we certainly don't want to prohibit them from doing that if that's their choice. But also we're not requiring, or cities are not requiring things that are hinge on approval that would necessitate the creation of an HOA. And I think that also strikes at the one that I mentioned earlier about sort of what is that balance of housing within the city where you, for example, we don't want all of your new housing to fall under an HOA because we know HOAs, while many are wonderful and neighbors appreciate that, they may not be the most affordable option. And so trying to balance those out. So I appreciate that. Member Butler, did you have a follow-up?
I did, Chair Bonner, thank you. So then I think what I would really want to recommend then is some kind of opt-out ability for HOA members. There's certain things that they can opt in and opt out for to not be covered under the HOA.
Okay, all right. Thank you. Member Green.
Thank you, Chair Bonner. So today really illuminated this issue of kind of the accidental HOA with the cities and this debate over, are the cities mandating this? What's going on here? And it reminds me of the issue that, our lack of inventory, lack of the starter home, what we just don't have in our market is this starter home. And the reason that there's such a barrier and the increased cost of new construction is because of these architectural requirements that cities have and lot sizes that have to be a certain size that drive up the cost. And I'm reminded of the missing middle bill. And that was meant to address that. And so I really see what we've talked about today as the HOA was a loophole that the developers are finding to get leniency on some of those requirements to be allowed to have their development. So, in a way, their issue isn't an HOA issue at all. It really goes back to the fundamental what these requirements are that cities are imposing that are limiting the types of housing that can be built in municipalities and driving up the cost so that there are no options other than this loophole that they've found with the HOA. So almost separating our groups work into issues that HOAs that actually want to be in HOAs. And then the issue that's really illuminated today of this is a compromise. Builders are getting something out of this. They're getting leniency on the requirements. The cities are getting something out of it. And then the person that's paying for it is the homeowner in the future. So, I really just am seeing this line forming here on our issues and wanting to just mention the missing middle and maybe have our group look at that and how that could solve a huge part of what we're looking at with issues. Thank you.
Thank you for calling that out, Member Green. And I know that topic is a little bit, to be honest, out of scope for us. But I do think I was going to mention, and thank you for calling that out, that I know the Housing Committee has been struggling with a number of issues and proposals on how to address some of these issues around housing affordability and a different variety of housing stock, whether it be single family versus multi-unit, talking about things like density, building requirements. There's all kinds of things that play into that in all honesty are maybe a little bit outside of the scope of our work here. And I think certainly we can call them out, but at some point we may need to, in our recommendations, point out that some of these may be outside of the scope of our work group. But it doesn't hurt to call them out and sort of underline them as the housing committees continue to do their work as well. I know Member Howard is particularly interested in a number of the issues that you just called out. And there is a number of very smart folks talking about these concerns and how we address a wider ability to create and sustain affordable housing, because that it appears the struggle right now is that, frankly, if we're going to be very blunt, there really isn't a whole lot of options for affordable housing, whether that's naturally occurring or new housing. And so there's a real struggle, if you will, happening. And I will also underscore that that is not just happening in Minnesota. That same push-pull is happening across the country. I hear that from legislators everywhere. So probably underscored by the earlier conversation about how we are so far behind on available housing, period. Member Taylor. Member Taylor? We'll come back to Member Taylor. Member Murray.
Thank you. I just wanted to layer on Member Green's concerns, specifically in the disability space, and that layers on everyone else's barriers. Development has been often prioritized for caregiver homes or for group homes, and like you're functionally not allowed to own your own home because of income-based requirements. Yet there are many incentives given to caregivers to build housing that then you must rent. So I'd like to see, as we are looking at, and I agree that it is somewhat out of scope for the HOAs, but as we are looking at this, to eliminate as many barriers as we can in HOAs, so that, because interdependence of sharing what you can do and trading care is what we need in the disability community. So HOAs are essential, but there are so many discriminatory practices that really people don't think of them as discriminatory. It's not intentional. It's just, oh, I don't need that. So you don't like, we just don't take the time to understand each other's needs. And then why I had brought up the intentional willful disregard for discriminatory practices is often then somebody does explain their needs, but it's not convenient to, or they have a personal grudge because they don't like that. And that's at that standard, I think we need to address damages and have possibly a more convenient or outside authority. Like, I don't know, we're talking about creating a OIG for fraud. Maybe we lump in the disability space and other spaces because agencies are so bad at regulating themselves. Maybe it goes there. I don't know. But what we have where like people are allowed to invest in companies and then like the investments are inflating every step of the supply chain that supplies housing stocks isn't working for the people who are getting housing right now. And anyway, I don't, sorry, I
Well,
don't
and
have
I
a
think
specific
thank you, Member Murray.
recommendation.
And we should also keep in mind that we sometimes spend a little time beating up on HOAs, but we have to remember that for some degree, some of these communities can be actually quite helpful for elders, for folks who may have disabilities. So, for example, when elders or folks in the disability community might not be able to maintain a lawn or shovel the snow or those types of things, it is helpful to have the ability to have communities and spaces where those services are shared. So that makes it a much more friendly and accessible place for those communities. And as we see our population aging, I think that will become a much larger issue. So I don't want to completely beat up on HOAs and suggest that they don't have a role to play. I just want to be fair in that regard. But I do think, Member Murray, you brought up something last night that I will just briefly mention here. In our listening session, Member Murray mentioned, how do we balance the need or the wants of the many against the needs of the few? And I think that is another thing that we always have to try to think about as we balance our recommendations as well. All right, I'm going to move on to would like to try as close to 12:30 as possible to move us on to the next part of the agenda to talk about quickly reviewing some of the other parts of the recommendations and sort of plotting out what the next couple sessions to get close to our report will look like in the last 10 minutes here. So with that, we have two members on there. I'll go to Member Taylor and then Member Howard.
Thank you, Chair Bonner. I'm actually glad Member Murray went before me because it actually is relevant to what I was going to talk about.
Yeah.
I know we talked a lot about cities today. I do think we need to put that exclamation point on the role of HOAs and the rules and governing documents on and the impact of them on discrimination. As you're saying, HOAs can serve a great function for seniors, people with disabilities. As a person with disabilities who sought a condo for the very reason you're talking about, because I could not physically keep up with home maintenance, external home maintenance in that way. I have not found this to be accessible in all ways. And a lot of the seniors in my community have really struggled with that as well. And this is because of things like not being able to advocate at all at board meetings. We're not allowed to speak for our needs. We have parking in the front that's accessible that we're not allowed to use. Only visitors are allowed to use it, even though we don't have accessible parking in our garage. It's assigned rent based on what our unit is, right? People with service dogs are not allowed to even come into our building unless they before they do provide the HOA with veterinary certificates, licensure, all these like really ridiculous things that the owner has to provide, sure. But even visitors with service animals aren't allowed to come into our building without doing that before. So the way that these things are playing out and the way that homeowners aren't able to even address them with their HOAs because they're not even being allowed opportunities to speak, I think I would like us to develop that set of required practices for governance, having more emphasis on collective governance in the way that HOAs are running meetings, are having communication, having those notice requirements, I also think having that authority that can be a place to weed through some of these rules that tend to have discriminatory impacts is a really helpful thing. Because as we were saying, if we bring this up to the Human Rights Department, we will then get assessed for all the lawyer time that our board is going to spend defending themselves or what have you. So it's never a place where homeowners that are experiencing these things have the ability to stand up for their civil rights, their property rights, any of their rights, right? And so I agree with you that the importance of discussing this topic is because HOAs serve a good purpose for a lot of people. They are can be a great place for first-time home buyers, a great place for seniors to land, disabled folks, etc. But the way that they are operating right now, and this is because they have for so long served as exclusionary communities, and the way that people who are able to serve on boards are often from one demographic, people that aren't necessarily working age, people that are from one racial and ethnic background are largely the people on boards. So that is having a discriminatory impact on the policing of other people's behaviors in these communities. So yeah, I want to see us just develop recommendations based on what other states' laws have done around some of the collective governance and some of the rights of homeowners in that way. I think that's really important.
Member Taylor. I also want to point to you, and hopefully you may want to check it out. I know that I did have a bill last session. If you go Google my name and look under chief authored bills, there is one on open meeting laws and proxy voting that might be of interest to you, and would certainly welcome your feedback on that.
Yeah, and I followed it. So yeah,
there
absolutely.
are also some new recommendations that we are considering to adding to that, but certainly would love to have your input on that. All right.
Thank you.
I had mentioned that we were going to try to cut off after Member Howard. But we'll get to Member Howard, and then I'll talk to you briefly, Member Cole, but we do really need to move on to the next section. Member Howard.
Thank you, Chair Bonner. I wanted to just touch on what Member Murray and Member Taylor were talking about with regard to discrimination and fair housing. I think it's an education issue. I work with a ton of boards, and I can tell you they don't know what the laws are and what they're supposed to be doing or not doing. And so my recommendation would be that there's some required fair housing training in addition to other training for board members. I do a lot of it, usually after the fact when they've gone through a discrimination claim and settled it and are required to do some training. But I think I'm surprised at what things that I think are basic understanding and the boards don't know and don't understand. And it's not their fault. I mean, there's no qualifications to be on a board in most cases, other than you own a unit in the association. So that would be my recommendation, is that we look at that from an education and training standpoint, because I think that helps everybody.
Thank you, Member Howard. If I might, if it's all right with you, I think one of the recommendation may be, because there was a conversation earlier about training specifically for board members and property managers, and perhaps the recommendation could be that as a part of that training, it should include a segment on fair housing practices. Does that seem appropriate?
Yes, absolutely. Thank you, Chair Bonner.
Okay, so Ms. Pollock, if you could add that as a recommendation as well. All right, Member Cole, very briefly, because we do need to move on to the next part.
Thank you. This sort of relates to the earlier conversation we had about roles and responsibilities, and it also relates to what Member Taylor was saying. My management company got the law firm to send me a letter telling me I'm not allowed to talk to the board without their approval. And if I want to say something to the board, I need to send a letter to Bloomington, and First Service will decide whether or not the board even responds. So I want a clarification on roles and responsibilities. And yes, it can go back to the training and how the roles and responsibilities are, and why the municipality is implementing boards and associations and not providing that training themselves.
I would also argue, and I just want to, well, I shouldn't say argue, that's maybe not the term I'm using, but add on to that. I think this is really a clarification around board governance. Ms. Pollock, specifically, we may want to call that out in the recommendation, but specifically that there need to be very specific, as a matter of setting up sort of the guard or the roles and it should include roles and responsibilities and expectations for board members as a part of statute, that there are some sort of generic best practices. Now, we do want to be careful that we are instructing the what, but not necessarily the how, that we are not too restrictive in that, but sort of basic rules of the road, if you will. All right. With that, we are going to move on to the next phase, and then I'm going to reserve the last few minutes just to talk a little bit about our last two sessions and sort of a tentative game plan for how that will play out in our last few minutes. But with that, unless there are any others here, I think what we'd like to do is suggest there are some potential areas where we might want to start revisiting some of the topic areas and some of the recommendations sort of ahead of the game. But I will say this, just in terms of the game plan, and maybe I should mention that first before we dive into that. So the game plan is that we have 2 additional sessions that are scheduled to review recommendations and sort of the outline of the report. Our intent is for the next meeting to sort of talk about what those recommendations are, as well, and that will involve a little bit of backlog grooming to eliminate some duplicates and so forth. And we're going to intend to try to bucket those recommendations into groupings, and then potentially have some breakout sessions. So we might have 3 breakout sessions during the first half hour, 3 during the second, and we'll ask members to decide which sessions they would like to attend, so that that group can take a little bit deeper dive on those recommendations and do any wordsmithing, if there's anything that needs to be combined or clarified, those kinds of things. As well as sort of ranking what among those might be the highest priority things that we may want to consider, things that might be out of scope, but we may want to still mention, those kinds of questions, and then have one person from the group report back. So that is our intent, and as well as walking through sort of a general outline of the report and what that looks like so that members can make suggestions. It is our intent to try and have a copy of that sort of cleaned up set of recommendations available to members before the meeting so that you can review them in advance, because I know some people like to see them up front and be able to mull them over and think them over, or use that to make recommendations. And certainly if you have them ahead of our conversation, you're welcome to send them over anything over to staff. So in case you don't get to be in that breakout group, you can certainly contribute that way. And then our last and final meeting, we will probably have a conversation about sort of finalizing the recommendations and reports and put it more in its sort of cleaned up format. But we will also need to make sure that as a part of that conversation, we need to get approval of that report from all of the members to make sure that that is finalized so that we can submit that to the legislature and make it publicly available for general public to see what our recommendations are and sort of the wrap up of our work here as part of the work group. With that, we do have a few minutes left. So I don't know, Ms. Pollock, if you have a specific place you wanted to go back to or place to start.
I don't. I defer to your leadership.
Okay. All right. Is there any specific area or topic that any of the members would like to start with? If not, we can sort of look into what those buckets are and kind of go backwards, but just wanted to throw that out. Nothing? Okay. Well, Ms. Pollock, we have a lot. We have 132 recommendations at this point. I don't know. I did hear quite a bit. Oh, Member Kimball, I'm sorry.
Oh, it's okay. Chair Banner, I'd like to recommend that there be a bucket that's about simplifying the oversight of HOAs. One of the key themes that I've heard has been trying to just clarify the scope of HOAs and simplify what that scope is, I would say is a theme. And another theme that I've heard has been around policies for governance and reasonable governance standards.
Yep. Yes, and I did try to label some of them earlier on around governance specifically, and kind of bucket those together. Um, So, some of the newer recommendations aren't in any of those buckets just yet, per se, but yes, I agree. Trying to put them in some sort of logical buckets where they make sense, for us to talk about that in our report, and of course that certainly helps Mr. George, who is sort of helping us outline the contents of that report. It certainly helps him as well in that pursuit. So I certainly appreciate that for sure. But I might ask you, Member Kimball, when you talked about simplifying the oversight and scope of HOAs, I'm not sure I'm fully understanding what you mean by that. Do you want to clarify a little bit more?
Yeah, I would say at the core of what I'm trying to get at there is across all of the different buckets that we've been talking about, I think there's been a theme that's emerged around just trying to simplify what HOAs are making rules about. So it's something that came up, for example, in affordability and civil rights today. It came up also in our last meeting when we were talking about municipal covenants. It came up when Heritage Park came and provided some testimony. And to me, that's the overall recommendation that's sort of emerging is like how do we put some policy guardrails in place so that the volunteers on HOA boards aren't trying to define all of the rules on their own.
So what I think I hear you saying is having a recommendation that we are creating sort of a best practices or a standard rules of the road, that are applicable to all HOAs to sort of simplify from association to association what those rules of engagement are, so that homeowners, boards, all of those better understand their roles and responsibilities within the HOA and what those expectations look like. Does that seem right?
Yes, and that connected with one of my earlier recommendations, that the scope of what HOAs are expected to try and administer is really limited to what's required. What's required as far as managing common areas and providing fines in order to be able to manage common areas effectively. And not rules about behavior.
Got it. Thank you for that clarification. Member Taylor.
Thank you, Chair. I just have a question. As we're going through these, do you want us to be getting very specific with like what we would like to see as specifics in the law, or would you like to leave that to the policy making and you'd like overall like
I mean, if you
cleanup and
had specific
recommendations?
suggestions,
Okay.
Member Taylor, certainly that is always helpful as it sort of might shape policy choices. I can't guarantee we will take all of them or that we can implement them or that they're all practical, but I certainly appreciate understanding the direction that work group members are hoping we take, and finding a workable solution to those.
Okay, thank you.
Do
That's
you have
helpful.
one in particular that you were thinking of?
Oh, I have specifics for a lot of them. So, so yeah, I'm just thinking about, I'll probably have to add comments to the previously given because I'll have surgery during the next session.
Sure.
But yeah, I
And you're
can
certainly welcome
note
to
to do
add them
that.
independently as well.
Okay,
And
great.
send them
Thank
to
you.
staff. Thank you. Member Murray.
I'd like us to add a bucket for sludge. I had sent this over to Andrew, but the term sludge in governance describes the excessive or unjustified frictions that make it harder for people to achieve their goals. It impacts satisfaction, trust, and access to services. Sludge also prevents us from fulfilling customer commitments. Like this is from the New Zealand. They have a really cool sludge audit that I sent over to attach for the minutes. But I think that is a neat definition that captures a lot of our and will help eliminate a lot of the extra requirements I'm hearing are being placed all over.
Okay, thank you. I'm sorry, I thought I saw another hand. And I think I appreciate you spelling that out because I'll be upfront with you. I was not entirely sure what you meant by the sludge term. So I appreciate you defining that, and I'm sure the public appreciates that as well. Um, all right. Let's see. Do I have any other members that who feel that there's maybe a gap in recommendations that we have covered in over our sessions that we have not addressed? Anyone? Member Zavadski.
Thank you, Chair Bonner. I am not sure because there's 132 of them. I'm just unsure if protections for workers within the communities, if that was listed anywhere since COVID, and this is for vendors, management companies, is anybody serving a community. There have been a lot of really difficult situations that, including life-threatening situations. And across the country, this has been brought up nationally where people have been unfortunately killed by homeowners regarding their HOA. And so I would like to see something around protections for people serving the communities.
So you're talking about sort of like safety standards or?
Yeah, I'm not sure where it would lie, if it's here or other places in the statute. An attorney could assist with that, but something around protection for people serving the community.
All right, thank you for that. Member Daly.
Thank you, Chair Bonner. I guess it's a more of a logistical question, specifically because this list is so long. We don't have access to this, do we, currently outside the meeting? Or am I confused and we do?
You do not currently have access to this. That's why I was mentioning that we were going to try to do a little bit of cleanup and get some of this material out to you before our next work group session so folks could review it.
Okay, yeah. It just is a lot to on the fly figure out what might be missing. So yeah, that'd be great.
Yep. And again, I think the idea is to try to get some of these into buckets so that we can have a deeper dive discussion in the next session, because you're right, it is a lot to try to digest in one giant body. And so that is my hope is that we can bucket it into some more targeted discussions so that folks can look at them, see what might be missing, and kind of take that little bit deeper dive on clarifying and finding gaps and things like that. Member Anderson.
Thank you. The hand up that was up briefly and then down was mine. I just made a comment in the chat to one of the other discussion points about boards trying to preclude people from talking to others or to each other. And my comment, it was not necessarily a recommendation, was just simply that I don't think that boards have the power to do that. I mean, boards should be governed by Chapter 317A. Same as I don't think a for-profit corporation can tell its shareholders not to talk to one another. So I just wanted to clarify, I wasn't making a recommendation so much as a comment to another comment. That being said, if this is a big enough problem where association boards are purporting to have that kind of power over others, then maybe it's something that could be looked at. But it seems to me it probably is more suitable for 317A than it would be for anything in 515B.
All right. Thank you, Member Anderson. Member Murray.
Now I'm absolutely blanking. I apologize.
We can come back to you, Member Murray. It's okay.
Like the question, I just remembered the question that I had is what functionally is inhibiting access to the thing so I can see it easily has been a consistent friction point for me making concise recommendations. What barriers are you and the legislative staff currently having that are getting in the way of you sharing this with us so we can collaborate? Because I would like to see any of those barriers, that should be a recommendation point for us because that's getting in the way of our work.
You mean in terms of
Not
recording
having
the
shared
recommendations,
documents.
or I'm sorry.
Yeah, that's inhibiting our work as a committee. And that's inhibiting that will inhibit HOAs from interacting for future recommendations because we're not going to be a one-stop shop for a fix. So I would just like to see whatever is getting in the way of using shared documents, and let's make a note of it. And let's see if we can get rid of it this session.
Yeah. Well, that's a much larger, more complex issue, Member Murray, around requirements for government and sharing and all of that. So, but we will create a copy that will get sent out to the members ahead of the next meeting, so you can review that in advance. All right, Member Kimball.
Thank you, Chair Boehner. I connected with the sort of two questions that we're talking about. For top priorities for us to talk about are the top buckets. I've already recommended simplifying oversight and scope and the policies and reasonable governance standards. I'd also like to add dispute resolution as something that I think has been a key theme and top priority.
That is one of the buckets I would like to see as well. Governance, dispute resolution, dissolution, open meeting requirements.
Yeah.
I think are all really big topics that I think fines and fees and foreclosure, I think are all topics, as well as I think there was one around licensing and registration and one specifically around sort of education and training. Were all sort of, as I recall, sort of high level topics. Okay. By the way, I do want to make a call out. Our researcher, who normally sits in Mary Davis, did send me a note, and I just want to make sure that I make this statement publicly. But she did mention she had to drop off the call, but we had a really robust discussion around covenants and discrimination. Discriminatory practices and the Human Rights Act and how that interplays. And she wanted to make sure that we knew that she is, by the way, one of the individuals helping us potentially put together language. And she said that she does a great deal of work on discrimination law and worked on the source of income discrimination law. Legislation for the last several years. Also worked on the part around removing racial covenants from homes in Minnesota, and that it would be very open to being an integral part of the conversation on how we draft references to that language to include it in 515B, an existing statute, to make sure that we have all of our bases covered. So I just want to because that was our topic for today, I wanted to mention that Ms. Davis is actually somewhat of a subject matter expert in that topic. And so we are in good hands on that front. So thank you. All right, Ms. Taylor, or Member Taylor.
Thank you, Chair Bonner. Just a few things that we might have left out, although I might have missed them. I think there should be a prohibition on banning home businesses and work vehicles. I think this is an accessibility issue. There are disabled folks that can only like do home businesses. It's also socioeconomic and a cultural discrimination issue. Um, I I think that boards actually, I just want to comment, I do think that boards have the power to restrict speech under contract law. They actually have more power than governments to restrict freedom of expression and speech, which is why it would need to be called out specifically as pulling away that power. And then one thing that I've heard over and over, and I know affects me, is I do believe it is out of the scope of this work group, but I do think we need to recommend a work group around the insurance issue to provide recommendations. I think that needs to be one of our strong recommendations. For instance, my fees when I moved in 3 years ago were $412. They're $715 now. Because our insurance dropped us from $50,000 a year to $250,000 a year from the one insurer we could find. So I really would like to see another work group form that dives into that and finds some solutions for Minnesotans.
Thank you, Member Taylor. I appreciate that. If I didn't find it in the list, I had intended to actually add something on that very topic. So thank you for getting ahead of that. And I wanted to say, I have I have not talked about it in this work group because it's a little bit out of scope for our work group to some degree. But I actually have been working with some folks in the insurance industry on some of the challenges around that issue, and some potential fixes. But I think it is probably going to take a pretty robust discussion to suss that out. So I think it's going to be a hot topic. But thank you for that, Member Taylor. All right, we have 4 minutes left on the clock. I do believe we have 2 sessions left. Since I don't see any other hands up, I will reiterate that it is our intent to, again, make sure to kind of clean up the recommendations a little bit, eliminate some duplicates where they exist, and sort of bucket them to help facilitate that deeper dive discussion. And it is our intent to try and have a copy of that out to each of the members in advance of the meeting. We would like to have it at least 24 to 48 hours at minimum ahead of that, so you have some time to review the document and have that ready when you come in. And then again, our plan is to hopefully to split into some work groups around those buckets to review the recommendations, take a little bit deeper dive discussion for those groups, make sure we can do the wordsmithing, combining, looking for gaps, things like that we may have missed or anything we want to call out separately, and sort of ranking what those things might be, so we can make sure that we adequately reflect that in a report for Mr. George, who is helping us put all that together. So thank you, Mr. George, for taking that on. And then, of course, our intent is on the following session to be able to review all of that product and sort of have something available ahead of the meeting so folks can review any last minute changes or recommendations. And then what we will do is to seek approval of that report pending any required changes. We'll give staff permission to make those changes made throughout the meeting and then approve that final report pending those changes. And I believe, if I'm not mistaken, we tentatively have that set up for Friday the 17th from 10 to 12 via Zoom, and Friday the 24th from 10 to 12 via Zoom. And I will make sure again that we try to get you materials in advance so that you can be prepared for those. I do know at least one member is not able to make those meetings, so I will encourage anyone to let us know, myself or staff know, if you also cannot make it. We certainly will try to get those materials out in advance and would encourage you then, if you have any feedback, to go ahead and submit that to staff so that you can feel free to participate as well if you're not able to be present in person for those Zoom meetings, because we certainly appreciate and value your input. With that, we do not have any other business for today. And we will work on getting that recommendation list cleaned up for everyone. And we will see you on the 17th. And again, thank you for all your participation, and a special thank you to all of the members who have been coming out to the listening sessions. I know that is above and beyond the group of the work group here, and I am really grateful that folks have taken the opportunity to go out and hear from the public some of their concerns. So thank you for that. And with that, we are adjourned for today.